Howdy, stranger, and welcome back to Fudbusters, where we're exploring myths and misinformation in the 2A community. I'm your host, Matt LaRosier, and I assume that, by watching this video, you're interested in purchasing a gun that's not presently available at your local store. Maybe you found something cool on Gunbroker, or one of them fancy auction houses. Or maybe you're ordering something direct from the manufacturer. So you pay for the gun, then suddenly you're looking for a stranger nearby to give 20 to 100 something bucks for the privilege of holding your gun for a few minutes while you fill out the federal equivalent of a warranty card. Heck, many of you watching have already done this a few times. But I'm here to tell you something interesting. The large majority of people doing transfers are doing them wrong. Let's find out how and why. If you want to skip around or just know what we're talking about today, I've got some timestamps here for all the bits we're going to cover.
While the host of Fudbusters is a lawyer, he is not your lawyer. That is, unless you pay him to be so. Either way, nothing in this video should be construed as legal advice.
Now, before we get too far ahead of ourselves, let's start with the basics. Here in the US, if you're going to buy a modern gun that's coming from outside of your state of residence, you're going to have to get it through a federal firearms licensee or an FFL. An FFL is somebody who pays the federal government for the privilege of dealing in firearms, but with that comes some responsibilities. FFLs have to keep a book of what comes through their hands. This includes guns they've bought to resell and also guns that are only in their hands for the purposes of transfer. They write down some details about the gun, where it came from, where it went after conducting a background check on the buyer. Now, I just want to take another quick step back and address what a lot of you might be thinking. Hey, we've got a fundamental right to arms, and the Constitution also makes it pretty clear that interstate commerce should be free-flowing. So why the heck do I have to do a song and dance just to buy a gun off a dude one state over? Well, that's because of the tortured way the federal courts have interpreted the Commerce Clause. This is a subject for another video entirely, but the super short version is this. This might be a surprise to you, but the founders were pretty spooked by unlimited government. What with the whole taxation without representation thing and all. Because of that, our Constitution established a federal government with limited, defined powers. One of those powers is the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Now, back then, the term regulate meant to make regular. It didn't mean a guy with a clipboard came to check if you were wearing open-toed shoes. This power was largely enumerated because under the old government, the Articles of Confederation, states would play protectionist games such as discriminatory taxes on out-of-state goods. This wreaked havoc on the national economy. So, for the longest time, we understood the Commerce Clause, when it came to things inside of our country, was more or less there to keep the Carolinas from bullying each other too hard. Fast forward 100 years or so, and you've got a fresh federal government, a big one, that wants big things. Social programs, laws, and regulation. The bad kind. The only thing standing in their way? That damned Constitution. Now, government programs that fell outside the scope of the powers enumerated in the Constitution were getting slapped by the court, rightfully so. So the president got angry. Then, in order to keep that certain president from stacking the court with judges, sound familiar, the Supreme Court took that part of the Constitution designed to protect free interstate trade and just started beating the ever-loving hell out of it. First, they took a couple baseball bats and they started slapping it about the knees. But even then, the Constitution still said pretty clearly the federal government only has a handful of powers. So they grabbed some chains and a length of lead pipe. They also got a can of that old school gasoline that lights up for no reason, and they just started going to town on it. Eventually, they pummeled the Commerce Clause to a point its own mother said, under oath, "I have never seen that dude before in my entire life." It had become, more or less, a permission slip for the feds to do whatever they wanted to anything that traveled across state lines. Yeah, I know. This is the reason most states have a fairly robust local firearms training community and why you're able to buy guns from private people at gun shows, for example. It isn't a loophole, it's because even FDR's federal government knew it didn't have the power to regulate purely in-state activity. The interstate regulations are the loophole, a loophole the court created in the 1930s to keep the New Deal alive. All that aside, and without getting into state-specific regulations, we've got a system set up by the Gun Control Act, which says if you buy a gun and it's from somewhere else, you've got to go see your local FFL man. He's likely an older gentleman, bearded, a bit fat, and 9 out of 10 times he's full of unsolicited bad advice. Oh, and he's going to charge for his services, naturally. And like I said in the beginning of this video, he's probably doing that transfer wrong. So let's get into one of the first and biggest issues. You probably had this one come at you in the seemingly reasonable, your gun's ready, just come on by with your in-state driver's license. This causes a lot of problems for people with multiple state residencies, students, and people who move around for work a lot. Loads of FFLs will only transfer a firearm to you if you have a driver's license from their state. They'll tell you forcefully that they've been doing this for umpteen years, and it's the law, son. Well, newsflash, it's not the law, and your store sucks. Let's take a look at the instructions page for the Form 4473, which is what we fill out every time we buy a blaster from an FFL. If we look here in the instructions, section C, in pages 5 and 6, it explains here pretty clearly that all you need to do is be able to prove in sum your photograph, date of birth, and place of residence. It even says a combination of government-issued documents may be provided. That means, for example, if you're a dual resident for whatever reason, you can provide an out-of-state ID with your photo, name, date of birth on it, then supplement it with any other government-issued document proving your address. For purposes of handguns, where unconstitutionally they're only allowed to give them to in-state residences, but again, story for another day. Now, yes, a driver's license is the most compact and recognizable document that can do this. However, it is not the only one and certainly not required by law. This is one of the unfortunately all too common instances where the law is actually somewhat reasonable with what it asks of us, but through a combination of misinformation, fudlore, and laziness, we wind up inventing stricter gun laws and applying them to ourselves. But if you're a student or otherwise multi-state residents, you can flip the form over and show them right there in black and white. We'll put it up for you again here. Here's a really annoying one for those of you who've sold guns online. So you sell a gun, right, online. You ask the buyer for their receiving FFL. They tell you their guy only accepts guns from other FFLs. This upsets you deeply. Yep, many people, including FFLs, believe that it's illegal to receive firearms from somebody who isn't an FFL. This is especially stupid when you remember the sole reason for getting an FFL is to enable you to engage in interstate firearms commerce. There isn't much I can say about how this got here. I have no idea how it wound up out there, but I know many people who've wound up having to pay up to $100 to have a local shop ship a gun to another jumpy FFL. In general, the receiving FFL just has to put down some basic personal information, your name, address, where you're from. As for how we got here, it could be because the receiving FFL thinks it's his job to pretend to be the FBI and verify everything in the world. It could be because he's angry you didn't buy it through him at his markup, or it could be because he is, in some other way, developmentally challenged in a fundamental manner. An epoxy fragrance connoisseur, perhaps, a prolific snacker of paint chips and sipper of ink drips. Let's set the record straight, though. The ATF themselves have said any person may ship firearms directly to a licensee in any state with no requirement for another licensee to ship the firearm. The only caveat is that non-licensees can't use USPS to ship handguns or concealable firearms. Instead, they must go through contract carriers like FedEx, UPS, you know the ones. This one is massively annoying. In fact, I can feel the stress on my atrial walls just thinking about it. Say you just bought a gun online. You ask your local FFL for a copy of their license to send the seller. Your local FFL gets irate, saying he will not provide his license to anyone but another FFL. He may have even refused to show it to his own brother. He believes his license to be a top secret document, him a harbinger of state secrets which must be handled with care appropriate for the Pope's own bathrobe. Let's just talk about how profoundly stupid this is. For one, you are required to have this stupid license on display at your place of business. If the feds expected you to keep it locked in a vault, why would they fine you for failing to literally post it on your wall? Now, I'm aware of some of the roots for this particular piece of lore. Such jumpy dealers may fear that you'll take a copy of their license and use it to purchase guns from other dealers at a gun show or something. Then the gun would be logged out to their FFL on the seller's books and yet never actually logged in. If it was subsequently traced, it would be a bit of annoyance for that dealer. Now, while stuff like that has happened, there's a much easier way to assuage those fears. Simply conspicuously writing on the copy that it's a file copy, not for face-to-face sales. Problem solved. Also, the license is public information to a degree. It's not special. If you pretend it's top secret, you only make it harder for people to get guns transferred, you troglodyte piece of... Lots of people will lead you to believe that businesses are justified in charging exorbitant fees because it's costly to transfer guns. Again, I'm not getting into state-specific policies, I'm talking about the general lay of the land. Here in Florida, for example, we have to pay $5 for each background check we process. All your guys gotta do is receive the package, log it in, and then log it out to you. We're talking about a maximum of 20 minutes of semi-skilled labor. For the most part, anything above the cost of the background check, if any such cost exists for them, is pure cheddar for the shop. I'm saying this, by the way, as somebody who runs an FFL too. We charge $25, and I'm pretty annoyed that we're the cheapest joint in the area at that price. So remember that next time your shop asks for $75 for a transfer, if you can, just say no. There are lots of tools like Gunbroker's FFL Finder to help you get hooked up with a more reasonable transfer agent. And you'll also possibly be helping out a smaller business in the process, one who doesn't treat your rights with detestable contempt. Now, some of you might be thinking, no, this doesn't affect your rights, right? Because blah, 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 it's coming through their private business. Well, they signed up to be a gatekeeper of all firearms transactions coming from out of state. When you're doing that in the gun world, I think it's pretty safe to say you should do it in a fair way. Loads of people think you've got to ship a gun in a Pelican case with 3 Swiss locks and a die pack. Nope. Box. Now, whether or not this will see the gun survive shipping is another matter. But just a box is perfectly legal. I've seen this story happen so many times. Someone moves out of states, they're leaving on a jet plane, don't want to take all their guns with them, so they ship them all to a dealer in the new state and pay a transfer fee on each one. No, you don't generally have to do this. Again, specific state laws aside, the ATF themselves have said any person may ship a firearm to himself in the care of another person in the state to where they intend to engage in any lawful activity. There's the caveat that if you send the gun, you address it to yourself in the care of someone in the destination state. They should just avoid opening the box and playing around with the contents. Remember, this part of federal law is for interstate transfers. If your gun is going to yourself, there's no transfer. Plain and simple. Of course, it bears repeating. There are state-to-state variations of many of the things we talked about today. Our discussion today was all in general terms for people living in relatively free states. It's important to keep abreast of what's going on and verify these things for yourself. If you're really concerned, consult your friendly neighborhood gun lawyer. Spreading misinformation about what is and is not legal is how we wind up following laws that don't exist. Until next time, remember, anything more than minimum compliance is self-regulation. Y'all take care.